Is case number 241599, Estate of Spieker versus Catholic Health Initiatives. And here on behalf of the appellant, which is the Estate of Spieker, is Attorney Brian Galligan. And here on behalf of Appellee Catholic Health Initiatives is Attorney John Maschman. All right. No hurry getting settled in there, Mr. Galligan, but whenever you get settled in and are comfortable, go ahead and begin your argument.
May it please the court. Counsel. Good afternoon, Your Honors. Thank you for the opportunity to be here. This issue on certificates of merit under Iowa Code 140 has been up before the Supreme Court, and now, as of last week, this court has decided 2 new opinions on the issue. And I don't think there has been much in the way of oral argument on the issue. So this is an opportunity to try to clarify some of the positions and also to try to figure out what remains after the Supreme Court spoke in the Banwart case, which occurred after the initial briefing in this case and the proceedings in the district court, as well as...
Or hurt you quite a bit, yeah?
I think there's some distinguishing facts, Your Honor, that I'd like to talk about. It certainly could be read that way, but I think there's another way to read it, particularly in light of the decision of the court 4 months prior in the SK case recognizing a litigation waiver. And I'd like to address that piece. That's on my list of issues to address. Certainly Banwart sort of reiterated the position that, there's this oath requirement that requires either the penalty of perjury language or the notarization of that. I don't think we can relitigate, obviously, and I know the court is bound by that particular ruling. But there are still unresolved questions. And if the court has specific questions, I'm willing to certainly field those.
Estoppel by acquiescence, is there a difference between a litigation waiver and estoppel by acquiescence? And if so, what is it?
I think there is, Your Honor, and that was one on my list of issues to address. And the district court in this case looked at the New Jersey decision in Knorr versus Smeal, okay? And in that case, the New Jersey Supreme Court had already passed on the waiver argument. But the court did look at the estoppel argument as something different, and did find that the defendants were stopped from raising the issue because of that. Now, the district court said, well, that was after the motions deadline, and so that shouldn't apply. But the reality is the court's reasoning in that case was much about the conduct of defendants sitting on their hands and the prejudice to the plaintiffs.
And to that point, does estoppel by acquiescence have anything to do with the dispositive motion deadline and its elements?
Not according to the court in Smeal.
And in Smeal, how long had passed where the defendants sat on their hands, so to speak?
I don't have the exact timeline, Your Honor, but I think it was a significant amount of time, as here, where the certificate was filed. This case was litigated for 3 years, and that goes against all the expressed intentions with respect to this statute, which is to get rid of cases early in the process and also to save litigation costs for both sides, because those implicate cost to the healthcare system, and the courts have recognized that in a number of different decisions where they've talked about the underlying purpose of the statute.
Doctrines like estoppel by acquiescence be used to thwart an otherwise unambiguous statute?
Well, I think that I take issue with the fact that this is an unambiguous statute. I think that the court looked at this statute and looked at the term affidavit and strictly construed it. However, the statute itself, the only trigger for dismissal is failure to substantially comply.
Follow Banwart in that regard? Aren't we kind of bound by the statutory interpretation given by Banwart?
I think there are differences in this case, particularly with respect to the fact that there was a subsequent affidavit submitted by the expert where the expert went back and didn't create a new affidavit, okay, like has happened, I think, in the McGonigal case, but said, at the time I signed my certificate of merit, the term affirm meant I knew I was under penalty of perjury. And if the purpose is to bind the conscience of the expert is acknowledging that his conscience was bound. And that's consistent with, for example, notarization, which is one of the options to satisfy the Miller-Banwart standard. The notary guide for the state of Iowa says nothing about penalties of perjury. In fact, the oath or affirmation that is the example for notaries to give, which would satisfy, says nothing about that and is very similar to what was stated on the certificate in this case, which is, pursuant to this code section, I affirm that the following are true and correct.
Part of that is the solemnity of having to do this in front of a notary. Kind of drives home the fact that, like, hey, this is important. This is something more than just signing my name normally, right? I mean, isn't that inherent in the notary process?
But if one looks at the notary process and who can become a notary and who is a notary and how it's done, even remotely now, that solemnity, I think, is in an ideal state but doesn't actually exist in practice here.
So going back to Judge Sandy's questions, I'm looking at Banwart, and it says, well, I guess before I ask that question, let me ask this one. Your claim of equitable estoppel is based on the same conduct that was found not to constitute waiver in Banwart. Would you agree with that? It was taking depositions. It was not raising an issue about a known defective certificate of merit. It was, continuing to litigate this thing like you would normally, and then however many years or months later, then coming in saying, "Ha, I gotcha," right?
Correct. And I think that goes to the argument by the defense and the position that, oh, this is an unambiguous statute. Okay, if it's so unambiguous, then what purpose is there for going forward with litigation and incurring the exact costs and eating up the exact time that the statute is intended to avoid? Okay.
But in response to that same conduct, which I think you've acknowledged is the same conduct at issue here, but you're going with estoppel or by acquiescence rather than waiver. The Supreme Court said, we have already recognized that defendants, by conducting discovery, do not constructively waive their right to challenge deficient certificates of merit, under Section 147.140 sub 6. Using the dispositive motion deadline as a bright line for determining waiver avoids a fact-intensive inquiry into how much discovery is too much. I'm having difficulty understanding what that fairly stark pronouncement that says, look, we're not going to get into this case by case. Is this too much? Is it not enough? What have you? Such that there's no waiver. I'm at a loss to figure out how that could then be estoppel. I mean, it seems like the same policy considerations that would make it waiver would make it estoppel, and since they've snuffed the waiver claim, why haven't they snuffed the estoppel claim?
Look at the New Jersey case, but more importantly here, I think waiver is still alive here because Banwart said going forward, this is the bright line, okay? And 4 months earlier, they decided the SK case, which recognized litigation waiver. And one of the factors in the SK case that the court recognized as extremely prejudicial was an intervening statute of limitations expiring. That occurred in this case. That wasn't present in Banwart.
Language in Banwart that says going forward, parties should rely upon this bright line rule rather than statements we made in SK. We note, however, that the outcome in SK is consistent with the bright line rule here. I realize it says going forward, but they also basically say, whatever mushiness we had in SK, it's the dispositive motion deadline. So
They didn't expressly overrule SK, Your Honor. That's my read. And I think that the extensive discussion of litigation, waiver by litigation in SK, and the recognition of that doctrine under Iowa law would at the very least seem to say that Banwart applies forward, SK applies backwards. And that gets into the last issue I'd like to address quickly, which is the retroactivity. The Frank case last week, which was decided by this court, touched upon that, but the Supreme Court has not talked about whether the Miller and Banwart decisions should apply retroactively or not.
change, right? I mean, these cases are interpreting what the statute means and presumably has always meant. They just haven't made a pronouncement on it. This isn't a situation like where Godfrey, where they all of a sudden, changed course, right?
One of the factors is deciding an issue of first impression not clearly foreshadowed, okay? And this is, as with respect to this statute and what substantial compliance means, this was an issue of first impression. And then you look at not clearly foreshadowed, you have multiple district court judges siding with plaintiffs in these cases saying these substantially complied. You have affidavits in the record in this case of counsel who were litigating cases for years prior to any ruling. There were no challenges were raised, payments were being made, and then you even have two Supreme Court justices in the Banwart case recognizing an interpretation exactly consistent with what we're saying here. There was certainly, no clarity or foreshadowing as to how this was going to be interpreted. And I think in fairness to litigants for years who litigated these cases, this needs to only apply prospectively. In this case, should fall into a safe zone where a retrospective application shouldn't apply.
Thank you, counsel. I see you're out of time, but of course you'll have your 5 minutes in rebuttal if you'd like. Thank you. And Mr. Maschman, whenever you're ready, you can begin your argument.
May it please the court. Counsel. Good afternoon. My name is John Maschman. I represent the appellees in this case, Catholic.
I'm sorry, I got bad intel on that, so I've been mispronouncing it. Sorry.
I respond to both. We represent Catholic Health Initiatives and Dr. Dennis Whitmer. This case is about enforcing the plain language of Iowa Code Section 147.140. The statute provides that if a certificate of merit fails to substantially comply, that failure shall result upon motion in dismissal with prejudice. That is what the district court did in this case upon finding that the certificate of merit was not in an affidavit form, and it correctly followed the mandatory language of the statute and dismissed this case.
Can you respond to the retroactivity argument that counsel has just made?
Certainly. We would take the position, as Judge Allers adverted to, that this is not a new pronouncement of law. This is rather a statement of what the law has always been. This law came into existence in 2017.
If that's true, why didn't you file your motion to dismiss shortly after the 60-day deadline?
We filed our motion as soon as there was a convincing precedent that came out of the Supreme Court.
Wouldn't that be new law?
It was not new law. It was an enunciation of what the standard is. Substantial compliance was a term that the court relied upon and determined that the parties, in order to substantially comply, need to either put it in an affidavit form in which the conscience is bound by invoking the penalty of perjury, or in front of a notary. This was fairly foreseeable, we would argue, in that the word affidavit appears 6 times in this statute. It was clearly important.
Again, why did you wait almost 3 years to file your motion to dismiss then?
We filed it as soon as we had convincing authority that that this would be a claim that we could, an argument that we could make. We were aware that matters were percolating. It was in the interest of our clients to perhaps keep our powder dry while matters were working their way up through the appellate courts. And upon
The argument for estoppel, though? Do you know what the 3 criteria are for estoppel by acquiescence?
yes, I have them right here.
Substantiate the first prong.
That has full knowledge of the rights and the material facts.
Yeah, you kept your powder dry.
I'm
You just said you kept your powder dry. Doesn't that satisfy prong 1?
that we were in, I fail to see how a party has full knowledge of the rights and the material facts. Again, the affidavit requirement was listed 6 times, and so I believe that the burden is placed upon plaintiffs here to
Counsel, did Banwart address estoppel by acquiescence?
I'd like to hear the answer to his question. Let him finish his answer, please.
I've lost my train of thought, so why don't you?
It just sounded like you were in mid-sentence there.
And then I turned my attention to the judge's next question, so I'll go ahead and respond to that.
Did Banwart address estoppel by acquiescence?
I believe that all of the arguments that one could raise for estoppel by acquiescence were addressed by Banwart, and therefore the authority is transferable. To the extent that they didn't explicitly rule about estoppel by acquiescence, I believe that the guidance from Banwart still compels the same result. If we consider the third prong of estoppel by acquiescence, acts in a manner that leads the other party to believe the act now complained of has been approved, on our part, we made no suggestion. We evinced no, we evinced no waiver. We were silent. Silence is not sufficient. It's common practice in the
Forward, would on the going forward theme, now that you have this clear pronouncement from SK and Banwart, would it be fair to say then in future cases, if some med mal plaintiff files a faulty certificate because of the failure to have it under oath or notarized or penalty of perjury, that you have the obligation to quickly respond to that, or you're going to run into an estoppel argument or a waiver argument now that the law is very clear?
I would argue that Banwart doesn't stand for that proposition, that it established this bright line rule so that we don't have to get into questions of whether how much litigation is too much litigation, or how much time prior to trial, or whether a statute of limitations has lapsed. I don't believe Banwart would stand for the proposition that now that defendants are on notice, they have an obligation to move quickly. The statute really only opposes obligations in one direction, and that's on plaintiffs. That is essentially the intent of the statute, was to force them to marshal their evidence early and to provide a sworn statement indicating the meritoriousness of their claims. The fact that there are no similar burdens imposed upon defendants, I think, would suggest that Banwart does not stand for the proposition that defendants are now on notice that they need to move quickly lest they waive a right. The statute doesn't contain any provisions that would suggest there is some sort of deadline or ticking clock, and both SK and Banwart essentially supported that position.
The same argument or same bases or same basis for your claim that equitable estoppel doesn't apply here, because we've set this bright line rule, it's dispositive motion deadline, the statute doesn't impose any deadlines on the defense?
Correct, yes. Essentially, yes. This does impose one-sided obligations. The purpose of the statute was to lower healthcare costs in the state and otherwise lessen burdens upon healthcare practitioners. So to the extent that it imposes one-sided burdens, I believe that was the intent of the legislature.
Counter argument that's coming from the plaintiffs is, how is that goal being accomplished when you guys know about this faulty certificate and then you incur the cost of litigating for a year or more? How is that consistent with achieving the goals of the statute?
Fair enough. However, I would note that even filing it before the dispositive motions deadline then saves the parties the arguing over motions in limine, arguing over jury instructions, having the cost of a trial. There are cost savings built into arresting the action whenever it occurs, prior to the dispositive motions deadline. And in fact, Curlin v. Monaster stands for the proposition, contains the language stating that the purpose of 147, 140 is essentially to, if there is non-compliance, it is to essentially defeat the claim. And so the purpose, besides arresting arresting non-meritorious claims early, it is also simply to ensure that non-compliant claims don't continue to burden the defendants or the healthcare providers in this case. So I believe it's consistent with the purposes of the statute that that waiver or estoppel not be found here, and given the recent pronouncements in Frank v. Hallman, there are nearly identical facts here. There were 3 years of discovery challenges. There were the expiration of a statute of limitations. There were experts exchanged, and the court found that those were not considerations that were relevant to determining whether the statute should apply. And because the facts are largely similar in this case, we would urge the same result, affirmance of the district court. Thank you.
Thank you, counsel. And Mr. Galligan, you've got up to 5 minutes of rebuttal if you'd like, and you can begin when you're ready.
Thank you, Your Honors. The issue of estoppel was not raised in the Banwart case. That case was decided and briefed before Miller ever came down. It seems the defendants want it both ways. They want to justify keeping their powder dry, sitting on their hands, and not raising this issue. And then they also want to say this is so clear and unambiguous that we should apply it retroactively.
And the Supreme Court stated, going to your constitutional claim, the Banwarts cannot even show Section 147.140 as ambiguous, and they fall well short of demonstrating that the civil statute is so vague as to be unconstitutional. So, I mean, that's a pronouncement by the Supreme Court that the code section is unambiguous, is it not? Well, and yeah, I'm not asking you to agree with them, but I mean, that's the pronouncement they've made.
So I also believe that if you look at the bases for looking at retroactivity, it's not about vagueness. It's about deciding an issue of first impression not clearly foreshadowed. Not clearly foreshadowed. And if you look at the record of this case, we have affidavits from counsel who practiced under this statute, who litigated cases with what the court would now consider unsworn affidavits. These cases were tried. These cases were settled, and often in many instances for lots and lots of money. If it was so clear, the insurance industry behind the healthcare profession would certainly want this issue raised. It wasn't clear. That's the reality. And again, that's why district court judges prior to Miller were finding that there was substantial compliance. That's why Justices McDermott and Oxley interpreted it exactly the same way we have, which is that affirmation is sufficient to accomplish the goals of the statute. And so, you know, I think that it's very hard to get around this particular requirement or situation that is highlighted for whether we apply a statute retroactively or not. And I think that if we look at, you know, the estoppel issue, you know, estoppel does require defendants to act, and it's separate and apart from what's written in the statute. It's a doctrine of justice. It's a doctrine of fairness.
I'm just struggling with, and I've already asked this, so maybe I'm just repeating myself and asking you to do the same, but I'm struggling with how the policy considerations are any different between waiver and estoppel.
I think waiver looks at the language of the statute and whether it's allowed. It would be one way to look at it. I would encourage the court to look at the New Jersey case again on that issue. I don't have the exact language, but that was a clear situation where the court had already said there is no waiver here. But there is, in fact, estoppel.
Counsel, my recollection of that case was that the New Jersey Supreme Court indicated that waiver wasn't applicable because the statute itself didn't put any time restraints, similar to Iowa statute, whereas the estoppel operates independent of any statutory language. Counsel, do you know of any other equitable doctrines that have been applied to, I think I asked this before, but let me ask it a different way, that have impacted statutes otherwise, like, for example, statute of limitations? Do you have any examples of like a tolling or equity that would do that?
COVID extensions are a precise example of that, where the Supreme Court during the COVID-19 pandemic extended the statute of limitations under principles of equity. That'd be a good example. Another one would be, adopting the discovery rule in cases. There are a number of instances where equity has allowed for the court to do that. Those would be some examples, certainly. And I think it's important to note that the Supreme Court did look to New Jersey when it was deciding Miller. And so New Jersey law does have some bearing on and how they dealt with the statute, on how we might look at the statute as well.
This might be an unfair question, but I'm going to ask it anyway. So just understanding, obviously, that we're an intermediate appellate court, and so we're always going to have to answer it upstairs. Given the nature of the holding and the rationale in Banwart, if we were to accept your idea on estoppel, what do you think the odds are of success on further review that the Supreme Court is going to say, yeah, that's different than the waiver that we nixed in Banwart?
I think that looking at what they did with the SK decision and then turning around 4 months later and doing something that most would agree is completely different, we don't know. There are a lot of these cases in front of this court, and I'm sure you're going to hear more this term in the court is, such that it has been very fluid in the last year and a half in terms of what's going to happen with this issue, truly.
Thank you.
Thank you, Your Honors.
Thank you, counsel, on both sides for your efforts and your briefing and your arguments here today. We do appreciate them very much, and they've been very helpful to us. We'll consider a state of I'm going to screw up the pronunciation, Spieker versus Catholic Health Initiative submitted, and we'll get a ruling out as soon as we're able to do that. Thank you.